Hi, everybody. I have to do it this way because I got thrown in Facebook jail for posting about CCW classes, even though they came back and said, no, we're going to put your post up, but we're still going to lock you up for 7 days. I didn't want to wait 7 days until talking to you about this. Ohio passed Stand Your Ground. Now, first of all, it doesn't take effect for 90 days. So today's the 5th. So 90 days from now is when it will take effect. What does it mean? That's the big question. And I've received phone calls from everyone from presidents of biker clubs to pastors of Baptist churches saying, what does that mean for us? Well, that's a great question. So let's talk about it. First thing I did is I went to the people that will actually be making these decisions in court. I talked to defense attorneys, legislators, judges, people like that. One of the scariest comments that I got is, well, we won't really know how this is all going to shake out until we've had a few court cases. Do you want to be that first court case? Man, I'd rather take 6 of these vaccines that have come out than be the first court case in Ohio for Stand Your Ground. The idea behind it was it is supposed to alleviate some of the mountain of proof from the defendant, you or I, that have to use our firearm. Now, I'm a Second Amendment guy. I'm a gun guy. I mean, hell, I've got my I'm going to take the trash out gun. Okay? I don't walk out my front door without at least a gun on me. But I'm all for some common sense and some reason when it comes to it as well. Previously, the 3 conditions of deadly force. You were an innocent party, meaning that you had nothing to do with the creation or escalation of the situation. You didn't start it in any way, shape, or form. Okay? That still applies. You were afraid for your life. You had a truly believable fear that you were in immediate serious danger of great bodily harm or death. That would be the reasonable person test in court. That any other reasonable person put in your situation would have felt the same way. That yes, I would have used deadly force as well. The third one would have been duty to retreat. I tried to avoid the situation. I tried to leave. I tried to walk away. That's the one that's being done away with. So, what that means now, so let's just use something very timely. Someone wearing a Confederate flag t-shirt gets harassed, or someone wearing a Trump t-shirt gets harassed, and they get loud back, and it's screw you, well, screw your mom too, and it goes back and forth. Then something happens and somebody draws a gun. Where do you assign blame? Where do you assign blame there? Understand your ground, it muddies the waters, but that's where we're at. So from the defense attorneys and all of this, remember people, fight A happens in the street, parking lot, whatever. Or rather, fight A. Fight B, and there's always that fight B, happens in the courtroom. So when you go to court, and you will, you're still going to have a prosecuting attorney asking you these same questions. Now, for me personally, I want to be able to go into that courtroom and go, here's my CCW. I've gotten some training, some education. I was an innocent party. I was minding my business. This person came up to me and tried to rob me, whatever. They put their hands on me. They had a knife, brick, gun, whatever. And I drew my gun and said, I just wanted to leave. I wanted to retreat from the situation. They wouldn't let me. I had to shoot them. That third one was now gone. So it's just, I was minding my own business. They came up to rob me and I shot them. Okay, that sounds good on paper, but it's not going to be those type of cut and dry cases. It's going to be the road rage incident that goes too far, the political debate that gets ugly, something like that. And now, with that duty to retreat removed, where does the line get drawn? So all I can tell you is this, people. Remember the fight B. Whatever you decide to do, you're going to have to justify it in court with a prosecutor that is wicked smart, trying to pull apart every single thing you say. And what happens if you get a prosecutor that did not support the Stand Your Ground legislation? Do you think they're going to make you a whipping boy? Probably. Do you think you're going to become the poster child of why this is a bad idea? Probably. So, an example that we use in class. If you wouldn't walk down that dark alleyway without your gun, there's no reason to walk down that dark alleyway with your gun. Don't start doing things differently. And I think that that's where we're going to run into some problems. Keep in mind, the stand your ground legislation is how we wound up with the Trayvon Zimmerman case, the parking lot incident over the handicap parking space. This all comes from stand your ground legislation. But it doesn't matter. The hay is out of the horse. You can't put it back in. It's going to become law in 90 days. And unfortunately, there are some groups already celebrating it as this great victory for the Second Amendment group. And you know what, truthfully, you know what I worry about more? I worry more about that they give us just enough rope to hang ourselves. That you pass stand your ground, you have a few shootings, and then we can take it all away. Take it all away. No guns. I don't know. And maybe that's just me looking at things with a hypercritical eye. But regardless, just be aware. Stay tuned. I will keep researching this. As a matter of fact, earlier today I was just on a phone interview with NPR up in Cleveland because they were trying to get a handle on this. The attorneys and that I've talked to today, it's all new. So they are looking at previous cases and trying to figure out exactly what the fallout is going to be from this. Things that look good on paper don't always turn into good laws. And I can teach duty to retreat in an 8-hour class. I cannot teach you good judgment skills in an 8-hour class. So I'm going to put this up on the YouTube page. Please share it. The best thing I can tell you right now is the first two conditions are more important than ever then. That one, you were truly afraid for your life or serious bodily harm. And someone saying, man, I'm going to kill you is not a reasonable cause to shoot somebody. Words don't hurt. You have to legitimately be afraid for your life or serious bodily harm, and you have to be an innocent party, meaning you didn't start it, you didn't escalate it, you didn't cause the situation to become worse. In other words, you weren't standing there running your mouth right back. Even though by law it says you can, remember, it's all going to have to come out in court, which is another reason why, and I'll end with this, although it was important before, it's even more critical now that you have legal representation. One of the first calls that I made to about this was to U.S. Law Shield and talk to their district attorney, or their I guess it would be our attorney for this area. He's probably one of the top 3 defense attorneys in the state. He is a $10,000 retainer, $500 an hour defense attorney. He's a pro-gun guy. He's gun vetted. And, he's still just starting to make sense of this. So, as a gun owner and as a CCW holder, I want to stay up to date on the laws as much as possible because of how it can affect me. I would encourage you to do the same. We will try to make it as easy as possible on you. I will continue posting these videos and doing lives as soon as I can get out of Facebook jail. And remember, nothing goes into effect for 90 days. For 90 days, from January 4th, I guess is when it was passed, it is still innocent party, serious belief of real belief of serious bodily harm or death, and duty to retreat. The duty to retreat goes away in 90 days, but those first two still hold water, and you better be able to prove that in court. I'll talk to you guys soon. This is the Gun Dude, Douglas Cooper, Arm the Populace, out.